Hi, everybody. We're just getting started. Um, so welcome. Hi, welcome everybody. We'll get started in just a few minutes. Hi, everyone. I think in case a few more people join us, we're still going to get started. So we're going to get started right now because I do think that we may use the entire time today. We're going to be talking about an intersection of a couple different documents that myself and other presenters have been calling family preparedness. The idea basically is that there are documents in Maryland, especially the standby guardianship and power of attorney, that are more relevant today. Um, you know, for a reason that I think we all probably don't enjoy. These documents can be used, and clients are often asking for them in case that they may be deported. And so these documents can allow parents, especially, to make plans and arrangements for their families and for their children in these moments. So I wanted to give one here. I know that I hope that everyone here is excited about this presentation, is excited about these materials, because I think that getting this information out is really important. And it's very important right now. So I've given a few of these presentations both to volunteers, volunteer attorneys, given to parents, given to families, and then given to care providers as well, about these documents, how to use them, and what they can and can't do for people. So today we're going to be talking a little bit about those two documents and how to use them and how to get them prepared for clients who may be in that situation. Um, we won't be covering, I will say, we won't be covering the sort of the immigration law aspects of this area, mainly the estates articles, and the estates articles and the documents that come from that sort of discipline about planning, about estate planning, that people might be using to navigate the financial questions that they have in this moment and navigate questions that they may have in this moment about who should care for their children in case of an emergency. So that's kind of what we're going to be talking about today. I've got a PowerPoint for us all to go through. Feel free to put your questions in the chat, and I will get to them. I might bounce around, answer some questions as we go, get to the questions at the end. I also will say that every time I've given this presentation, I think people have brought up a new or novel situation. So if there's anything new, um, that comes up that we won't be able to answer today, I will take down your question and get back to you about that as well. So with that introduction, my name is Stephen Coppin. I'm the Tangle Title Project Manager at the Maryland Volunteer Lawyer Service. And so in that role, I'm helping pro bono attorneys every day learn how to do different skills, training them, and helping them take on cases for low-income clients. As I said before, in this moment, we're going to be talking about standby guardianships, power of attorneys, and how to make families more prepared for the worst and prepared for emergency situations. I'm going to, let's put on my PowerPoint. So we've got the PowerPoint up. And like I said, if you have any questions while we're going, just drop them in the chat. But as I said before, MVLS, we don't do immigration law or immigration cases, but we were really looking for something in a way that we can contribute to people who are in the most need right now. So one thing that we could do, and one thing that we've been able to do, is expand our knowledge and our resources related to standby guardianship, and especially develop the skills on training volunteers like yourselves on how power of attorney and standby guardianship can be used in conjunction. So the Tangle Title program, that is what we call our, sort of our program that's about helping, I say it's about helping families preserve family homes, but it also covers our estate law. It also covers a little bit of our property law at MVLS. And so the purpose of this training is to give volunteers the information and tools they need to understand how power of attorney and standby guardianship work in Maryland, and then also learn how to fill out the forms. I will say today we're going to focus a little bit more on standby guardianship forms because that is sort of a little bit newer. We have some resources on power of attorney as well already that I could point to. Our existing estate planning videos and trainings cover power of attorneys pretty well. So I'm going to be really covering the ways that it's different in this context, or additional ways you might want to consider some new vectors of the power of attorney form. So this training is for those who already work with immigrant clients in the community, and it's also for those who are trying to do more for that community or trying to be more helpful, but may not have that immigration law background, maybe coming from an estate law background. So at the top level, what is the power of attorney form? In Maryland, this is a legal document that allows an individual to grant another person authority to act on their behalf for a variety of matters, including financial, business, and healthcare. But when I say healthcare, I want to make sure that I'm meaning arranging for some of the stuff around it. When you're making healthcare decisions in the moment, there's actually a different document for that. The standby guardianship form, in Maryland, it's a legal arrangement that parents designate another individual to care for their children in the event that the parents become unable to do so themselves. So there's some interesting, there's a lot of unique fact patterns with clients who are coming for questions, especially when it comes to standby guardianship. So that's what we're going to be getting into a little bit. But standby guardianship in that way stands at a couple intersections of law. So sometimes there are family law issues that come into play. Sometimes there are property law issues that come into play. But there are a lot of things at the top level to understand to even get below into those intersection points. Again, in general, we want to combine these two documents, and we can use these two documents together to create a robust plan in case of emergencies, like an adverse immigration action. And you'll hear me use that phraseology a lot today. an adverse immigration action, because that's actually what the standby guardianship form uses. So the standby guardianship form uses the phraseology an adverse immigration action, which is pretty broad. It could be pretty much anything that the client would feel is an adverse reaction for them. But oftentimes they're contemplating, considering a deportation or a detention. So clients need to be in this moment when you're having clients with these issues, they really specifically need to be counseled to consider um, outside circumstances and kind of pragmatics. Um, so one thing might be home access, school access, etc. Um, I see actually a hand. Someone raised a hand. Miriam. Miriam, could you put your question in the chat? Do you have access to the chat feature for that? I'll give you a second to see. Okay, great. Thank you, Miriam. Um, so you want to consider when clients are in this situation, you really want to consider the outside pragmatics, because the whole point that you're trying to get these documents across for often, when clients have been asking us for these documents, they want to make sure that their kids, in a very real way, have things taken care of. So can still go to school, can still eat, may need to get to different places, may need the ability to communicate with their parents or other family. So there are a lot of pragmatics here that I think are outside of, when a client comes to you with the strict legal question of how do I perform this standby guardianship? How do I make this form? Another big thing we want to talk about um, in general is that you want to fill out these forms in English. For the power of attorney, that is a recommendation. It is generally just an acknowledgement that the parties you'll be giving the form to generally want to see the form in English, and that's what will make it the most effective. But with the standby guardianship form, it actually does need to be, it is required to be in English. So that's why for that one, you definitely need to make it out in English. So you'll notice that if you look it up, there will be an English form, a bilingual form, and then a form in Spanish. If you go to a general, resource for the standby guardianship form, you can find it at the Maryland Courts website. You can also find it, a great resource is the Standby Guardianship Project in Maryland. But you want to use the actual English form for the standby guardianship. And in the consultations, I also want to point out and I want to raise that these are not necessarily easy consultations. As data planning attorneys, I think we often come from a perspective where we are counseling clients. We're used to having difficult conversations about someone transitioning or someone passing away. Maybe that's a skill, a muscle that we flex. But these clients, if they're kind of consulting with you about these issues, they have a different risk that they're evaluating. So their goals are often different. And the standby guardianship often is a little bit more of a triage option. It's an option that's kind of mitigating damage. It's not really going to avoid that damage for them. I think a question that comes up often in this context with a client who might have they might have uncertain documentation status. They're asking about their standby guardianship designations. They're asking, should those people have, should they have citizenship status? And then the follow-up question after that is, what happens if I don't have anyone I can recommend or assign who has status themselves? What should I do? That's where these conversations can be difficult, because standby guardianships and powers of attorney in here, they are triaging the situation. They're not really, solving, fixing the problem. They're really just mitigating the damage that's going to happen to these families. In the slideshow, And when we post this slideshow, these slides will also be available. In the slideshow, you can find, I've included links to the forms, also to areas where you can get more resources on these forms. So for the power of attorney, I've linked to the People's Law Library here. I've also included that we have the form on our website under our estate planning resources. With both of these forms, power of attorney and standby guardianship, they have statutory versions. So that is also why they are very useful, and why they can be specifically used in this context, is because they have statutory versions that are easy to access. So the form on our website is also the statutory version. What is used for? What is the power of attorney used for? It's used for granting an agent authority to take actions on the principal's behalf. They can step into your shoes and take actions to the same extent you could. There are definitely downsides. That is another thing to consider when you are having these counseling sessions with clients who, are for the purposes of this training, the client in our minds is they're coming to us imagining being deported, and they're thinking about assigning power of attorney to someone. So they're making their choice in a difficult choice environment. So you do need to counsel them and really, really go into, does it make sense to give this person power of attorney? Should we make it limited? Would you give this power of attorney to this person, in a general situation, if there were no pressing danger for you? Because the power of attorney is a broad document, especially if you use the general form, especially if you make it effective immediately. Some of these things that I think our general assumptions or general postures on the power of attorney form, we need to reconsider or think about it more specifically when we're going through that consultation with a client. So say, do we want this to be a general power of attorney, or do we want to make it more limited? Do we want to, are there specific things we're contemplating? What if we're talking about a child, about care for a child? What's the child's network like? Who else is around? Who else can help and in what ways? I've had a few clients come and ask for powers of attorney because they have homes. They didn't necessarily have children. They did have homes and assets that they just wanted to make sure someone could take care of, in case that they were to have an adverse immigration action. But anytime we're making powers of attorney, we need to know about that broad authority and that potential for abuse. Some top line things about power of attorneys. When does it become active? Immediately is often my recommendation. When we're in sort of general estate planning consultations, I think immediately is often my recommendation. I think it has often been immediate power of attorney has been my recommendation often in these contexts too. We call that it's the immediate version versus the springing version of the power of attorney. But you can also include non-immediate options if the client requests. So when certain people agree that you are incapacitated, or commonly in the medical context, or when we're planning for medical emergencies, only upon the written certification of your treating physician, or when two doctors may make that same certification. So some of these are ways that we've created triggering power of attorneys in the past. In this context, people have often asked whether or not they can make that same adverse immigration action the triggering event. I say yes, you can. You just want to make sure that you're not writing it as the drafter in such a way that it will make the power of attorney substantially harder to enforce. So we'll talk a little bit later about how you can prove that adverse immigration action has occurred, and what kind of proof you can provide. And you may want to consider writing that into the power of attorney as the actual triggering condition. Important to know about the power of attorney, it can last indefinitely or it can last any stated period of time. You need to name an individual often we recommend with backups. And you want to consider whether or not to general or limited. Like I said before, your default assumptions, if you are coming from a practice where you're making power of attorneys, may be different here. I generally recommend that people get advice before signing, but to you, many of you attorneys, that's what they're coming to do. And just as a reminder, this document needs to be notarized. The execution, apologize. The execution of this document needs to be notarized, but the standby guardianship does not need to be notarized. When you're considering on the power of attorney who should be your agent, you want to consider and you want to advise a client to consider trustworthiness. You want to consider factors that may tempt them to take your money for themselves. So for the power of attorney for the client, we often talk about, I think my often default advice is saying, could you give this person this money and trust that it would be used on your behalf? Can you give them just the cash in their hand, and would they use it on your behalf? Do they handle their own money well? Do they have financial knowledge, education? And in this context, we are considering whether or not they are what their status is, the person who is the agent on the power of attorney for. Now, a lot of times, I think people say, is it okay if they're not a citizenship? They are not a citizen themselves. And I do think that it's not legally required that the agent be a citizen in the power of attorney form. And I think that it really just gets into the specific facts of the situation. This is just another thing to plan and consider around when you're actually making that choice. Some other things I wanted to highlight. I think often there is, in the long form of the power of attorney, there is a gift giving provision where you can indicate who the power of attorney can give gifts to, how much they can give to them, and for what purposes they can give gifts to them. I think that comes into play more often when you're considering about taking care of children. You might want to actually use that gift giving provision. So if you're in typical practice, you're making a lot of simple power of attorneys, and you're making a lot of simple power of attorneys, and the gift giving provision is something you often skip, or you skip it in the sense that you take it out often. I think you may want to consider bringing it in. People also might be looking for more tailored solutions. A lot of the clients that I've worked with thus far on standby guardianships and power of attorney in conjunction, they've been looking for a more tailored solution than just a general power of attorney. Because they're not looking for someone to take care of them and manage their affairs specifically, or step into their affairs generally. They're really considering what is going to happen to my house, what is going to happen to my kids. And you can also confine the power in the power of attorney. So if you're, a practitioner who's coming from the perspective of usually using the long form general power of attorney, and you want to bring it back, you want to tailor it. You may want to do that more thoughtfully than you are usually doing, or some of the things that your automatic advice has been before. You may want to reconsider if that is appropriate in this context. So just for examples, for anyone who hasn't seen, I wanted to point you out some of the important decisions of the power of attorney, including the effective date. As you can see here, this is the statutory version. So that effective date here says the power of attorney is effective immediately unless you have stated otherwise. The special instructions in the form comes later. But another thing I want to point out here is the termination date. So that is how you would make this power of attorney ineffective after a certain point. The termination date is right here underneath the termination date heading. But for the effective date, for the starting point of the power of attorney, if you want to make it anything other than the day that you sign it. You actually include it in this separate special instructions section. Just talking about execution and storage of the power of attorney, signed by the principal, who is the person making the power of attorney, witnessed, notarized, and you want to keep it in a safe place. So tell your agent where to find it. Don't give them a copy until they need it. And just as a reminder, the copies of the power of attorney are as effective as original. Going to standby guardianships. As I said before, I've included some resources here for you to be able to find the form and access it after this presentation. So it is used for the standby guardianship. You are allowing someone to have a standby ability to have guardianship over minor children. So there are three main types of emergencies. In case of a physical incapacity, a mental incapacity, but also an adverse immigration action. And this is on the statutory form from Maryland, these three options. If you are using the standby guardianship form, you actually get this automatic 180 days from the point that it becomes effective, from the point that there is that triggering event. There are 180 days of automatic effectiveness using this form. After that 180 days, you actually would have to ask for judicial appointment to continue being standby guardian. I've included from the Standby Guardianship Project right here, just some more. They have an excellent FAQ. I can't recommend that resource enough. Just some things in general that often come up. Do you need both parents' consent to the Standby Guardianship form? Yes, the answer is yes, with exceptions. You need the parents to there are exceptions on the form. You don't actually need them both to be present at the same time, which we will get into. They can actually fill out the form at separate times, but you can include it all together. But you do need both parents' consent, or rather anybody with parental rights. Does it take effect immediately? No, as we discussed, there has to be a triggering event for the standby guardianship form. Does it need to be notarized? No, but it does need to be witnessed. And then the last option is it is most effective when it is paired with follow-through efforts. So follow-through efforts, as we discussed before, you have to think very pragmatically. So assembling important documents, because we're talking about on behalf of a child, on behalf of a minor child. So assembling important documents like their birth certificates, the parents' important documents, children's passports, the standby guardianship form itself, emergency contact information, if the children have a social security card. And then we've also included an ICE contact waiver. Because we are specifically we're thinking about adverse immigration action. The ICE contact waiver is, it just allows for someone to be reaching out about someone's status who might be in detention or might be in deportation proceedings. So it's actually a waiver about the communication about that person's status. So if you are in a situation where a client anticipates or is planning for the risk of being deported or detained, getting that waiver complete is actually a really important part of that process. That is, once again, that's kind of on that line between immigration and estate planning. But that contact waiver, it's a simple thing that you can do to get that ready for that packet, as we put right here, this packet of papers that someone's going to need. Picking the guardian, here's some qualifications that you want to consider. So they do have to be over 18. Criminal convictions, you're going to want to consider this and advise the client, because this is one where when you fill out the form, the standby guardianship form, the statutory form, it doesn't ask that question about criminal convictions. But at any point that someone might need to seek a judicial appointment, that process will consider their criminal convictions. There's a 100-day limit, 180-day limit to the effectiveness of the standby guardianship form. And then I wrote, unless judicially appointed, they have to go get a judicial appointment. It is so you want that judicial appointment after the document. It's after the document would take effect, and then we've already discussed how to use the ICE detention waiver form. Other things you're considering, it has gone. I have gone without saying it, but stepping back to the most elemental point. For people who are asking for standby guardianships, they are considering whether or not this person is appropriate and going to adequately care for their children. So I think that shouldn't go without saying. And definitely when you're sitting with a client, you want to counsel them on if this person is the person that they want to appoint and give that ability in an interim capacity. Something that's important about standby guardianships, they don't abrogate, you're granting someone essentially concurrent rights. You're not, the parents aren't giving away their rights. If there's any point where the parent disagrees with the standby guardian, the parent is still in control. They haven't given away, their custody to this person. They've given them sort of a concurrent ability to come in and help. But that is an often a point of confusion. In case you haven't, this is your first time seeing the forms, I've included some of the sections here. So this section right here is the designation of standby guardian section. You'll see that if you download the statutory form, there are 5 pages. The first 4 pages are like the initial petition. They're the first petition. But that 5th page is actually a consent form. So there are some interesting ways about the way that this was formatted that, can be confusing your first time filling it out. For instance, it's written in with I or we in a lot of sections, saying that 2 parents could be filling out the form together, or they could be filling it out separately. One parent by making the initial form, and then the second parent by making a consent. So you'll see that this is written I or we designate this person. And you'll see that, that could be confusing, but just to clarify, you could have 2 people filling this form out together, 2 parents filling out this initial form, or you could have one filling it out and then a second consenting to it. So you'll see I or we, the names of the parents, designate the name of the standby guardian, whose address is blank, telephone, email. And then you see this distinction here, person or property or person and property. This is an important distinction that we'll get into. Thanks for the question, Miriam. We'll get to it. I'll get to that question after I finish this section a little bit. So the person or property, or the distinction of person and property. So this is a really important distinction that we're going to get to in the next couple slides. But I just want to flag that it's a little bit about it, kind of how much authority that they would have over what spheres for the child. Right here, you'll put the names of the children and their dates of birth. One thing that recently came up: what if someone has children with different sets of parents? In that case, I would generally recommend that you make different standby guardianships. You would make different forms based on the kids' sets of parents, because there'll be different parties signing on each of these forms. As I said before, how do we prove that triggering event happened? How do we prove that there was an adverse immigration action? For people who may be undocumented, you want to make sure that you get their A number. That is like um, it's the marker, it's the indicator of that person, and you'll be able to use that number to um, search the detention databases. Um, and I think that there are a lot of asterisks. There are a lot of asterisks in this space. The space is changing truly on a day by day, week by week basis. Um, but this is currently the best advice, for making sure, trying to find where someone is at. So making sure the trusted person, that person who's getting the standby guardianship or the power of attorney, the person that we're, trusting as our agent here, has that A number and other identifying information so they can find someone using the databases. This distinction, guardian of the property, guardian of the person. So guardian of the person gets to make non-financial decisions. So housing, but in which house will the kid be? Medical care. Are they going to go to the doctor for this? Education, taking them to school. Which school are they going to? Clothing, providing for their clothes, not necessarily buying their clothes, but making sure that they have them, and then, you know, getting their food, everyday needs. That's kind of the thought of the person, everyday needs. Property, you're making financial decisions for the child's personal needs. You could also apply for benefits on their behalf. You can also pay any taxes that you may need to. This is just, I would say that there's not generally a best or worst. I think working in this space, talking to parents, they are obviously very wary of what is happening, and they also want to, are rightfully very protective of their children. So I think that talking to them about these distinctions is really important. I also generally, there's some overlap here. There's some overlap here, but we want to make sure that the standby guardian will be able to do what they need to do. So earlier I mentioned that you might want to get an idea of who the network is taking care of this child. Are there other family members? Are there other trusted people involved? And what are they taking care of? What do they do? How do they help? How do these things interact with each other, basically? We had a question about the ICE waiver. No, and I appreciate you asking for the clarity. So I'll take that one. I'm going to come back to your question, Miriam. But I had a question about the ICE waiver. The ICE waiver is to authorize the parent's information with a third party. So that is why we're filling it out, so that someone, if you want that person, um, that trusted person is often potentially helping coordinate with lawyers, um, coordinating with other parties, coordinating with other family. So it is just authorizing third party. It is a third party authorization related to their information. So that is the purpose of discussing in this context. And also just because, it's kind of part of that planning packet, those packet of documents that we might be helping someone prepare. So the ICE waiver helps facilitate. Yeah, it does help facilitate information. So executing the form for the standby guardianship? Yeah, of course. Executing the form, both parents are needed unless they fall into an exception. There are a lot of exceptions that are on the form. Some of the most common ones are contemplated by the actual statutory form. So if the parent abandoned a child, like they are just not findable. If the parent lives in another country, if the parent does not have parental rights, these things are actually on the form and contemplated by it. I think generally talking to you all as practitioners, if both parents are with you now, we can all fill it out together. That's incredible. If they're not, you often have to instruct how to use this 5th page, this consent form. It can be confusing as the person making the form that the initial packet does include this 5th page that is a consent. The consent is not actually required to make the first 4 pages valid if you have all parties with parental rights. The standby guardian also needs to sign the form. That is a unique aspect of this form. The standby guardian accepts the designation by signing. If it comes up, their signature does not need to be witnessed. And what do you do after this form is filled out? You think about the logistics. You think about access to schools. You think about if that person needs a key to the house, if they need to actually get into the home, because also these emergencies will happen without warning and at any time. So I think pragmatics, when I wrote access to schools here, I'm also considering that you might want to have this person on a list of trusted persons. Each school, I believe there's some variety in how schools approach visitors and approach people coming to get children, especially at different ages as well. So knowing what the requirements are at the school, that this third party person who's not a parent could come by and pick up the kid, be a trusted person, getting that set up ahead of time is also really important. I'm going to go back to a question from Miriam. Can you still do a standby guardianship if both parents live in another country? That one I am going to take for later and try to get back to you on that one. But my initial thought would be, yes, you could execute that form, as long as you validly executed it. If the child was staying here, both parents were abroad, I do think you could execute it. But I would have to check on that for you. I'll get back to that in the Q&A, but we're going to move on for now. The consent form, as I said a few times, if you download this form, there's going to be 5 pages. The first 4 are the standby guardianship form. The 5th page is this consent. So this is what you use when you have one parent who's not present. Truly, and it's very, I've had these sessions where it's just the parent was delayed at work, or they had to go do something, or they had some appointment, so they couldn't come to the appointment with the attorney. So you would give that consent form, you would get that other person to fill out this consent form, which the consent form, when you get to the bottom, needs to be separately witnessed because it's somebody filling it out at a separate time. But it basically says here, your name, name of the person signing, agree with the designation by the other person of the standby guardian, and puts their name. You'll also note here that there can be alternates for standby guardianships. You can include, just like the POA, you can include people who would become alternates. I included here a few of the resources, a few additional resources. Resources for people to get help with standby guardianships. If you are providers talking to people, resources for people to also try to get more help with immigration support. Law libraries are a great resource. Self-help centers are a great resource. I've noticed, talking to a few people about this issue and talking with clients, there are a lot of family law issues that are also coming up, and unresolved family law issues that create a lot of issues for the standby guardianship process. So there are a lot of additional things that need to be taken care of, and we might need to try to get people help with. So there are family law self-help centers as well. There are also pro bono resources here as well. For our process, we have powers of attorney, but also for standby guardianships right now, if you're a volunteer who is interested in doing that, you should reach out to me separately, because we are, understandably making sure that volunteers are, well-trained and well-supported in those areas for standby guardianship cases. Um, just a just a recap before we get into Q&A time. We've kind of talked about how power of attorney and standby guardianship work and work together in Maryland. Um, we've given you some resources. There's some resources in the PowerPoint, and then we can talk more about that later, where to refer community members with complex situations for legal advice and assistance. And I think that in doing this, one important consideration is you really want to flex that muscle that you may be using as an estate planning attorney. If you are thinking through logistics and thinking through the little things about every step of the process. So if someone is coming to pick up a child from school, but they are not the parents, that there's a process for that. That's something we want to consider in advance. If someone has to get into the house, they need like the garage codes or they need physical keys to the premises. These are things we want to think about in advance. So there are a lot of pragmatics here, and that intersection of power of attorney and standby guardianship can help, make those arrangements. So for now, I am going to stop my share. And I would love to, if anybody has more questions, get into some of them. And I have the forms on hand if we need to reference them and look at them. But it's an open call out. We've got 15 minutes here for questions. And if it's easier, we can have people raise their hands now that we're out of the main presentation. Or you can type it in the chat. Just in general, I think we're trying to get this information out to as many volunteers as we can because we think that the need is very real. We've been able to do some volunteering in the area. We've been able to have some volunteers take some cases. We've been able to do a few clinics in communities. The difficult thing is also that the communities themselves are understandably very insular right now. So there are a lot of challenges as well, but a lot of people are using these forms right now to set things up, get things arranged ahead of time. Got a question. Hi, Jagan. To what extent would these documents allow for court appearances? Or would the proponents first need an order awarding guardianship? That's a good question. I think that the documents would, I think it really depends on the types of court appearances as well. I'm not sure which exact court appearances you are contemplating. But the power of attorney could be used to allow someone to get counsel on your behalf. So to get the attorney who would then be able to assist you at court appearances. If you're contemplating something more like family court, I'm not sure. I guess I'm not quite sure which actions you're talking about. But to the extent of obtaining counsel, the power of attorney can be a great tool for that. feel free to ask a follow-up. And maybe to spark more questions, I actually would like to pull up the one thing that we didn't cover fully, but we can go more into is the exceptions to someone's presence in the standby guardianship form. I'd really like to show you all that. But please feel free to put some more questions in the chat.
And did you really know you know? When you're given a choice of two bad things, you have to choose one.
So I'm going to show you, I'm going to put on screen the standby guardianship form contemplates what you should do with other parties with parental rights. So, as you said, as you can see here, other parties with parental rights, when they have not consented to designation, you can see some options here. Some of the most common options, I think, in a lot of situations are contemplated here. The person is unable to give consent, that they abandon the child, they no longer have legal custody, they live in another country. You don't know the parentage of the child. This last one cannot be located and the following efforts have been made. So then in there you would put some editorial about what you have, what your attempts have been. With the initial form, when you start to use it, there are just different bars, because once you use the form, you then theoretically would be going to go to court, and that's going to be a higher bar. So the form in a way is a lower bar because it is statutory. You are filling it out at home or with an attorney, and then you're using it. Is it necessary to do a standby guardianship power of attorney? Also, is the standby guardianship similar to SIGIS? Standby guardianship and power of attorney, I think that is a little case by case. It kind of depends on who it is a little bit more about more tools in the basket. So is it necessary? I would say kind of depends, but here's some of the reasons why they're useful in conjunction. So the power of attorney can give someone a little bit more wider access to accounts, especially. So the actual methods of getting food, getting clothes, taking them to paying for the doctor, these types of things. If that standby guardian wouldn't actually have those resources themselves, or you want to make sure that they're able to use your resources or the client's resources to, get that stuff done, then the power of attorney really combines there. Like it really helps that, become effectuated. Standby guardianship is similar to SIGIS. I do have to say I'm not as familiar with SIGIS. So I can't actually speak to, how they stack up right next to each other. But I do think that as it's coming from the parents, there's a little bit of a difference there, since the parents are making this motion with standby guardianship. But again, I will look into that. But to the first question, they're not necessary. You don't always need to combine standby guardianship with power of attorney. Like it's not like you need to combine these two things. But it is like maybe a lot of the things that are actually practical about taking care of a child may not be achievable without access to the person's resources, using the power of attorney form. also, I mentioned this earlier, but I just want to reiterate this a little bit, is that you may have like in actual real life, someone may be, they may have multiple children with different sets of parents. Um, so I do think in those cases you want to make different standby guardianship forms to make sure that you're taking care of each child specifically, which may involve then trying to get different types of consents from different people, or like one person's with you and you can do that petition together, and then you have to make a different petition with a consent. Or you can do that form together and you need to make a different form and get a consent for that form. We didn't see yet the signature block, but you can see here. Um, I think this section here makes it can make it a little confusing, but there is an or here. There's a separate signature block if someone was signing to help someone who physically could not sign. And there's a separate signature block in the form that's included for that. But if you have the person with you and they are signing, you do not need to use that. And the witnesses sign here. And standby guardianship signs. Standby guardian signs here. I think that we've got to all the questions in the chat. But do we have any more? We can also go back to power of attorney. I do know that we went very quickly through power of attorney to focus on the newer topic. MVLS, we have several power of attorney resources on our website right now, including our base estate planning video. So you can get, I think, a broader concept. If you're not familiar with that form, you can get a much broader concept from that. Okay, cool. Feel free. I'm going to, thank you all for joining. I'm going to include my email in the chat right now in case you want to follow up with any questions after today. You can also find my contact information on the MVLS webpage under the staff listings. But I'm going to include my email in the chat as well. There's a lot of information sharing going on right now, especially when it comes to this form and using it, and new questions in the area. And is this still the best advice this week compared to last week? So please, reach out if you have any questions, but I'm going to include my email in the chat before we hop off today. You're saying the power of attorney itself grants certain authorities, but it only grants part of what we discussed. So the question is, the power of attorney itself grants certain authorities, but only grants part of what we've discussed. The power of attorney is a pretty broad form, but then there are certain, honestly some certain categories of things that are just not in the power of attorney. So one of those categories of things is actually relating to parental rights. Power of attorney does not really talk about parental rights at all. It doesn't deal with that. The default form, the statutory form. The statutory form also doesn't deal with healthcare decisions. So with the healthcare decisions context, you might want to go into an advanced medical directive. But with this sort of parental rights area that the standby guardianship is really talking about, that's kind of why we have a different form. So the power of attorney itself would not give someone the right to essentially take care of your child if you just filled it out. It would give them certain things that they could use, like they could access your bank account, they could handle your real estate, stuff like that. And it would give them certain things that they could use to your child's benefit, but they wouldn't actually technically have the right to be taking care of your child unless you filled out some other form, like standby guardianship form. I hope that answers your question. Yeah. I think so. So the comment is so to cover all of the angles using power of attorney plus a standby guardianship is best. I think generally yes, because you're thinking about someone taking care of the children, minor children, but then in your stead, like truly you're absent, and the client is like absent, and then you're also thinking about how would that person actually be able to take care of them using the client's resources. So I think often you're going to be doing both in conjunction and trying to get them to work together for this shared goal. Awesome. Um, well, I really appreciate you all coming in during lunchtime. I hope you all have a great day. And I have included my email if you want to reach out. So thanks for joining. Thanks for joining MVLS's webinar today, and I hope you have a great rest of your day. Sorry about the email. I think I put it in private chat. You should have the email in the open chat now.
I really think that. That's the level of care thing that.
Okay, great. Um, well, you all have a great rest of your day, and please email me if there are any ongoing questions, and then um, Miriam, if you could email me and I could get back to you, that'd be great. Okay, thank you. Have a great day.